The broadcast is now starting. All attendees are in listen-only mode.
Hi everyone, my name is Lee Pucker. I'm the CEO of the Wireless Innovation Forum, and I'd like to welcome you all to this inaugural webinar in the forum's new webinar series. We're pretty excited to be starting this new webinar series, and we're hoping it brings value to you all and the community at large. Our webinar today is an introduction to spectrum policy technologists. Just a few bookkeeping items up front. First, I want to let everybody know that we're recording this webinar for future use, and we'll be making the webinar available publicly later. The slides for the webinar that are about to be presented will also be made publicly available, and we'll send everybody who attended the link to the slides after the event is over. If you have questions, we're going to keep everybody muted during the presentation. If you have questions, there's a question window on your control console with the GoToWebinar tools. Please go ahead and type your questions in as they come to you throughout the presentation. And then at the end, I'll read those questions off to the presenters. And you also will have the opportunity to raise your hand. Again, there's a little hand tool on your interface, and you can raise your hand to ask a question directly of the presenters as you go. And we can, again, we'll do all questions at the end. So that's the background information, and with that, I'd like to turn it over to the first speaker, Peter Tenhula. Peter Tenhula is the Vice President and General Counsel of Shared Spectrum Company. In this capacity, Peter serves as SSC's top legal executive and senior strategic advisor. She's responsible for planning and directing all aspects of SSC's legal, external, regulatory affairs, focusing on legislative, regulatory, and intellectual property aspects of commercializing SSC's dynamic spectrum access technology. Peter also serves on the board of directors of the Wireless Innovation Forum and chairs the forum's regulatory committee. And prior to coming to SCC, he had 15 years with the United States Federal Communications Commission. So Peter, with that, I'll turn it over to you, and if people have any questions, again, I encourage you to type them into your questions window, and we can manage them along the way.
Thank you, Lee. Welcome. Good morning, everybody. It's a pleasure to be picked for this inaugural webinar with my friend Ari Fitzgerald. So let me dig in and into the presentation. I hope everybody can see the slides. The outline overview of the presentation this morning is following. Lee just did the introduction to me. I'll do a quick introduction of the forum's regulatory committee and our other speaker, Ari Fitzgerald. Ari will provide an introduction to his firm, quick overview. I will provide a overview of the spectrum regulatory establishment, focusing primarily on the U.S., but touching a little bit on the international components of that spectrum regulatory establishment. Ari will give his insights and inside tips and tools and tricks for advocacy in the spectrum policy process. And then both of us will tag team the substantive area about the wireless regulatory framework and hit some examples of some proceedings, especially coming out of the FCC. And as Lee mentioned, we'll have Q&A at the end. And as Lee mentioned, the slides will be available afterwards as well. So looking forward to your questions, and hope we raise a lot of questions. This is a quick summary of what we hope to cover. It's a high-level introduction, designed for technologists that really have never or rarely exposed to the regulatory issues here in Washington or anywhere in other regulatory arenas. So some of the key concepts we'll talk about are spectrum allocations. I'm sure you heard about licensing regimes, assignments, the service rules, authorization of unlicensed devices, and the legal aspects of protection from harmful interference. So let's just do a little more introductions quickly about the Wireless Innovation Forum's Regulatory Committee, which Lee mentioned that I chair, and my vice chair is Paul Colazzi, who I used to work with at the FCC. The committee works with the Regulatory Public Policy Committee to establish a global regulatory framework promoting the adoption of reconfigurable wireless technologies and advanced wireless systems. So we basically promote the work of the other groups within the forum as well, and kind of inform the regulators about the work of the forum. We're facilitated by a regulatory advisory committee, which is made up of former, current regulators or regulatory experts, and we support the forum's overall strategy in these areas. And I highlighted the education component because that's kind of what we're doing now. We also put on help put on technical conference and workshops. We'll put on a workshop coming up in end of November, December. Regulatory workshop be held in Crystal City, outside Washington, D.C. So I'll let Ari introduce Hogan Lovells real quickly, but before I do that, let me introduce Ari, who is a partner with the law firm of Hogan Lovells. He is the forum's outside regulatory counsel. His practice focuses on wireless, satellite, international communications, and internet-related issues. He joined Hogan and Hartson, the predecessor for Hogan Lovells, from the FCC, where we worked together. He worked for about 3 years as legal advisor to the FCC's former chairman, Bill Kennard, and advised the chairman of wireless international spectrum policy issues. Prior to working at the FCC, he worked at the Office of Legal Counsel in U.S. Department of Justice, counseling the White House and federal government agencies on constitutional and administrative law matters. Ari, you want to do a little quick pitch about Hogan?
Thanks a lot, Peter, and thanks again to you and Lee for both hiring Hogan Lovells to serve as outside regulatory counsel to the Wireless Innovation Forum and also inviting me to participate in this presentation. Hogan Lovells is a full-service law firm with over 2,400 attorneys and 43 offices around the world. The former Hogan and Hartson merged with Lovell's last May, and the combined firms basically operate in every possible regulatory area you can think of. It's a large multi-jurisdiction communications regulatory practice. I have partners in Europe who do what I do in the U.S. I have partners in Asia who do what I do in the U.S. We regularly provide strategic and legal advice on a wide range of spectrum policy issues before the FCC, NTIA, the U.S. Executive Branch, EU, national regulatory authorities within Europe, regulatory authorities in Asia, and the ITU.
All right, thanks, Ari. Now we're going to dig into the rest of the presentation. And the first part is, again, about the regulatory establishment. And here, focusing on the U.S., the way the organization of spectrum regulation is divided between a part of the Commerce Department, the NTIA, National Telecommunications and Information Administration, and they govern the use of the spectrum by federal users like the National Defense, law enforcement, Homeland Security, emergency services, etc. On the FCC side is where the non-federal users, commercial, private, state and local governments, public safety, and media, TV, radio, are regulated. Obviously, there's lots of back and forth between the two. I just want to point out the FCC is an independent agency, kind of almost like a branch of Congress, but independent, and we'll go into that a little more in our segment. There's a group called the Interdepartment Radio Advisory Committee. It's chaired by NTIA with 19 federal agencies and the FCC serving on that to also coordinate the spectrum issues among the various agencies. The NTIA, NTIA reports basically to the president. It's also not only is the government spectrum manager, but also an advisor to the president. The FCC rules are contained in the Code of Federal Regulations, various parts of that, about 4 or 5 volumes of that book there. And then the NTIA rules that govern the defense and other government agencies are contained in the Manual of Regulations, Procedures, Federal Radio Frequency Management, or also known as the Red Book. So these are the kind of the sources of the regulations for the U.S. regulatory establishment. And kind of a layer on top of this is kind of the international regime, and that comes from the International Telecommunications Union, or ITU, which is a treaty organization coming out of the United Nations. And then there's I'll get into this in a second, there's a radio communications sector that handles the spectrum-related thing. So that's just a broad overview of the at least the U.S. regulatory establishment. It doesn't include other branches, other areas of government that does have an impact on spectrum, and I'll just mention these quickly. The State Department, liaisoning with ITU and other international community. There's Congress that's definitely involved a lot, and other agencies within the executive branch, including the Office of Management and Budget, Office of Technology, Science, Policy, OSTP, and there's other agencies that have relationships with the FCC, for example, FDA, Department of Homeland Security, and things like that. So it's a much bigger regulatory establishment than you would imagine. But these are obviously the two main players, and when you put the ITU on top, the other ones. Quickly, just the FCC organization. Ari's going to get into the players a little bit more detail, but the key focus here, where things happen, are in the Wireless Telecommunications Bureau, the Office of Strategic Planning and Policy Analysis, and Office of Engineering and Technology. These are kind of the key players when it comes to spectrum, and then the commissioners obviously make the final decisions. And the NTIA is headed by an Assistant Secretary of Commerce, and the key organization in the NTIA is Office of Spectrum Management. They're the folks who kind of run the IRAC, which I mentioned before. And there's another organization you should be aware of, is the Commerce Spectrum Management Advisory Committee, which is an outside group of spectrum experts that advise the Assistant Secretary on spectrum management issues. Also quickly, the ITU, our organization, the radio communications sector, things that are kind of more crucial here is the folks that put together the conferences. The World Radio Conference is coming up, and then the work that goes on is in the study groups and special committees are listed here. Primarily technical work, but there's also some regulatory actions and recommendations that come out, like ITU Study Group 1, for example. Okay, I'm going to turn it over to Ari now to talk about the do's and don'ts and tips and tricks for the spectrum policy process. Ari.
So drilling down a bit and focusing primarily on the FCC spectrum policy making process, there are 4 general ways for the private sector to propose changes to FCC spectrum policy, and I list those 4 ways on this slide: a petition for rulemaking, request for rule waiver, congressional legislation, and a white paper or extensive ex parte filing on the issue. And I will describe these general categories in more detail later on. If the FCC is initiating spectrum policy changes, there are basically 4 general ways that they do that on their own motion or in response to private sector requests. A forum or en banc hearing, task force proceeding and report, a notice of inquiry, and a notice of proposed rulemaking. And as I indicated, I'll go into more detail about those later. I think, Peter, in advancing the slides, I think we need to control. Okay, great. On this slide, I discuss a bit the advantages and disadvantages of the various options available to private sector parties that are trying to initiate changes in spectrum policy. what I have done here is listed the 4 categories that I mentioned on the previous slide across the top of the page, and then decided to focus on 4 key objectives that any private sector party would have, and any private sector party that was interested in promoting a particular policy change would have: securing a speedy final decision, framing the issues in a way that best allows it to achieve its goals, building stakeholder coalitions, and developing a comprehensive public record. So if you let's first talk about the petition for rulemaking, and a lot of this is also discussed on slides 14 and 15 following this. So what I'm about to do here will cover those, those 2 slides as well. If your primary goal is securing a speedy final decision, then a petition for rulemaking probably isn't the way it wouldn't be your best first option, because the process can be quite lengthy. When you file a petition for rulemaking, you'll probably have to endure at least 2 comment cycles, 2 public comment cycles. The first being the comments that would be requested by the Commission immediately after you file the petition for rulemaking, and then the Commission will digest those comments, and if it likes what it hears from the public, it may issue an NOI or an NPRM proposing your change. And if that occurs, there's another comment period, at least 1 in the case of an NPRM, and possibly 2 if the Commission launches the proceeding with a notice of inquiry. Framing issues, if you're using the petition for rulemaking approach, not a bad way to go. Allows you to explain in detail your proposal and how it achieves the Commission's policy objectives. If your goal is to build stakeholder coalitions, not a bad way to go either. Petition for rulemaking does allow for significant public input because of the comment cycles. You can also use your petition. You can essentially market your petition to groups that you think will be supportive of your proposal. If your goal is developing a comprehensive public record that will allow the Commission to make an informed and thoughtful decision, then petition for rulemaking is also a fairly good way to go, again, because it does allow for a wide range of input on the issues that you raise through the comments process, and hopefully, as a result of that, the Commission's decision will be more thorough and more defensible in court if it gets to that point. Let's talk a little bit about requests for rule waiver. Well, if your primary goal is securing a speedy final decision, not a bad way to go. Of all of the 4 options that I mentioned on this slide, rule waiver is probably the fastest, mainly because it isn't required, the Commission is not required in all cases to seek public comment on a rule waiver, and in fact, those that are done on delegated authority by a bureau, many of them get done without public comment. If your goal is framing the issues appropriately, not a bad way to go either, because in your waiver application you do have to sort of justify the waiver as being consistent with the public interest. You also have to show how granting the waiver would be consistent with whatever the Commission's policy objectives are at the time. Building stakeholder coalitions, not necessarily a good way to do that. Mainly because a lot of waivers that are granted are company-specific, and when a waiver is company-specific, it is harder to develop a coalition in support of it. Now, some waivers have precedential value, but again, many waivers that are granted by the Commission, for many of them, the process is not as transparent to the public. Some of them are granted without a written decision. So again, a little bit of problems if your goal is to build a stakeholder coalition, but not impossible. If your goal is developing a comprehensive public record, it's okay, an okay approach to use. Again, if the Commission decides to put it out for public comment, as I noted before, a lot of waiver applications are not put out on public comment. Let's move to congressional legislation. If you're interested in a speedy resolution, congressional legislation is probably the worst way to go. Anyone familiar with the process that we've basically been going through here in Washington lately with respect to the budget and the process that we're likely to FCC as we get to debates about the debt limit knows that the congressional process is a very slow process. However, I advise clients to take advantage of that process in situations where the commission may not be inclined to go your way on a particular policy issue and where you think there might be a piece of legislation moving, and where you believe that there is a member, especially a member of the House Energy and Commerce Committee or the Senate Commerce Committee, those committees with oversight authority over the FCC, who may be interested in promoting your views, may agree with you where there may be constituent ties with a particular member of Congress who has authority, who sits on that committee and has oversight authority. Peter and I are quite familiar with the ways that the congressional process has been, the legislative process has been used in the past. We were both legal advisors at the FCC when Senator Stevens did it on countless occasions for Native Alaskan tribes that had spectrum-related concerns. It's actually done quite a bit. Again, the legislative process is a little, it's difficult to predict when it will actually work. And as I said, it is fraught with its own issues, but it is a vehicle that is available in certain instances, in certain limited instances. Not necessarily a good way to, if your goal is to frame the issues and comprehensively lay them out, not necessarily the best way, mainly because many members of Congress and their staffs, they end up having to, they by necessity, they're sort of generalists by necessity. The congressional staffs, while they have great people, they don't always have the resources to keep on top of the latest technological developments. The staffers who are working on telecom issues are working on other things as well, and therefore they may not have the deep, they don't have the deep knowledge that professionals at the FCC have on these issues. If your goal is to build stakeholder coalitions, not a bad way to go as long as the process, the legislative process, is relatively transparent. If you're trying to sneak something through under cover of darkness at night, obviously not much of a public process. If your goal is developing a comprehensive public record, not necessarily a good way to go either, because again, congressional staff may not be as familiar with these issues as the experts at the FCC and other specialized agencies, and therefore may not, have the capabilities to ask all of the right questions that would allow for a record, a robust record to be developed on your proposal. The last approach that I want to talk about is the white paper or extensive ex parte approach. Again, this process is used, or this vehicle is used often when a private party has a goal that it wants to achieve, and there is an open proceeding that touches on the issue that the private party wants the commission to engage on in a new proceeding. The party does have the ability to file an ex parte, sort of raising the issues in the open proceeding. Not necessarily great if your primary goal is to secure a speedy final decision, because for the reasons that I mentioned with respect to petition for rulemaking, the commission will likely seek comment on the issue several times before resolving your proposal. Pretty good for framing issues because it gives you the opportunity to really write up a robust filing, to prepare a robust filing that can then be used with stakeholders and with the commission to vet the issues that you brought to their attention. Pretty good about building stakeholder coalitions because you have the document that essentially tries to show why accepting or implementing your proposal is in the public interest. Not necessarily great for developing a comprehensive public record, but when the commission does decide to put it out for comment, it can be a good way of developing a comprehensive public record. And let me just speak briefly about that issue and why I said what I said about that. When you file an ex parte in an open docket, the folks at the commission that are working on that already existing docket may have, you know, their primary goal is to try to resolve the issues that are pending in that docket. And it does take some work to convince them that this ex parte, that they need to pay attention to it. And again, just doing that may take a little bit of time. If you are able to convince them of that, then you can actually develop a robust public record on the issue. But the Commission actually has no obligation to do anything with your white paper. It could sit in perpetuity if the Commission decided that it's not, your proposal is not something that the Commission was interested in pursuing. So let's now move to slide 16, where we talk about some of the, do a comparison of some of the FCC-initiated options for promoting or changing or implementing spectrum policy. So one option that I want to talk about is the forum or en banc hearing. This is actually, this vehicle has been used more recently by the FCC, mainly I think because it's an easier way to convey to the public the message that the FCC cares about a particular issue and that it wants to engage in policy making in the area. Holding a forum or an en banc hearing is a lot easier than preparing a notice of inquiry or an NPRM. And also, it's a lot easier, it's a lot more digestible by, it's a lot easier to convey the Commission's interest in promoting a particular policy goal by through the use of a forum or en banc hearing than by putting out a 100-page item that only Peter and I are going to read. When the Commission puts together a forum or a hearing on a particular issue, it's much easier for the press to cover the event. It's also much more accessible. Those types of fora are much more accessible to the general public. And that's one of the reasons why I believe the Commission has been using that vehicle more in recent years. Another way to go is to use the task force approach, and we've seen that recently with the National Broadband Plan, and when Peter's boss, former Chairman Powell, was the chairman of the FCC with the Spectrum Task Force report. A great way to, again, communicate to the public that the Commission cares about a particular issue, a great way to really explore in depth the issues, and certainly with both of the reports mentioned on this slide, the Commission did that. One downside to the task force report is that it does require the commitment of significant staff resources. Those staff, everyone wants the really highly engaged, energetic, intelligent staff at the Commission working on these task force reports, and obviously those people would be doing other things if they weren't working on the task force report. So the staff resources have to be redeployed away from the typical bread and butter work that the Commission does: rulemaking, licensing, spectrum allocations, those issues. So let's move to the next slide. This slide talks about the two traditional options that the Commission has used to communicate to the public when it wants to make changes in spectrum policy: the notice of inquiry and the notice of proposed rulemaking. A notice of inquiry is launched when the Commission has not yet fully developed a specific proposal in a particular subject area. It's really used to, it's a document that is issued to the public seeking comment from the public on an issue, and it's really used when the Commission hasn't really fully developed a proposal but wants to seek general information about a particular issue that can then be used to formulate a more concrete proposal, which it would put in the second vehicle that I am mentioning on this slide, the Notice of Proposed Rulemaking. The Notice of Proposed Rulemaking, or NPRM, is used generally when the Commission has decided to move forward in a specific policy direction and has already and has decided to make certain tentative conclusions about how it's going to move forward. Briefly, a little bit about the legal process, the legal framework that applies to FCC spectrum policy rulemaking. The Administrative Procedures Act applies, and to any decision that the Commission makes in the spectrum policy area, And the APA requires that any agency findings and decisions must be set aside if they are arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law. That's a highfalutin way of saying it's got to be consistent with the law and it has to be reasonable. Courts will defer to the FCC's expertise on spectrum policy and technical interference issues, but those decisions have to be reasonable under the APA. And I'm having a little trouble advancing to the next slide.
I'll do it.
Thanks, Peter. Let's talk a little bit about the division of labor among FCC bureaus and offices. Spectrum allocations, unlicensed operation, equipment certification issues are handled by the Office of Engineering and Technology. They do a very good job in that area. Service and technical rules for licensed services are handled by the bureaus with primary authority for those particular services. So with respect to commercial satellites, it's the International Bureau of Broadcasting, it's the, and including satellite broadcasting, it's the Media Bureau. All wireless issues, fixed and mobile, it's the Wireless Telecommunications Bureau. Public safety, it's the Public Safety and Homeland Security Bureau. General policy guidance at the Commission, a number of offices are involved in that, including the Office of Strategic Planning and Policy Analysis, the Chief Economist at the FCC, and the Chief Technologist. Legal considerations are handled by the Office of General Counsel, legislative issues by the Office of Legislative Affairs. And briefly, just the key players in spectrum policy. The most important player, of course, is the FCC chairman. He sets, and it's been a he only up to this point, he sets and manages the FCC's policy agenda. FCC bureaus and offices work technically for all 5 of the commissioners, but in reality they answer to the chairman. He decides when items are put before the full FCC for a vote, and this is a very important power because if he's not ready for an item to come to the to be examined and decided by the full commission, it doesn't come up. The remaining FCC commissioners are also very important, primarily because the chairman needs their votes to get anything done at the commission, anything on his agenda. Also, over the years, some commissioners have been more influential on spectrum policy matters than others. And right now, I'd have to say that in addition to the chairman of the FCC, 2 other commissioners, they're both Republican commissioners, Meredith Baker, former Assistant Secretary at NTIA, and Robert McDowell, another commissioner, have both shown a keen interest in spectrum policy and have both become influential in their own right, mainly because of their backgrounds in the area prior to working at the Commission. As I mentioned previously, the operating bureaus are also very important. Senior staff at those bureaus wield significant influence over policy. Many spectrum policy issues are handled on what they call delegated authority, where really the bureaus have total authority over the decision, and so you want to make sure that you engage the bureau significantly in any of your spectrum policy proposals. Finally, again, I've talked a little bit about OSP, the Chief Economist, Chief Technologist, and OGC, all very important actors in spectrum policy matters. And then the Commissioner's legal advisors, very important. Generally, the same set of advisors cover all wireless, international, and OET issues. They meet regularly to discuss the issues, vote items on circulation, prepare for Commission meetings. And again, one of the reasons why they are influential is because they're not subject to the Sunshine Act, which prohibits the commissioners from meeting together in groups of any more than 2 outside of an open meeting. The legal advisors are not so restricted, and therefore they can get together and work out issues, and they do. And Peter and I were both legal advisors at the Commission, and we're quite involved in that process. Finally, a few do's and don'ts for those interested in promoting spectrum policy ideas at the Commission. Most of these are pretty commonsensical. just tips about how to improve your chances of being successful. Please do use experienced engineering, legal policy, and communication team when you're engaging the FCC. Try to meet as much as possible, as early as possible, with the FCC staff and interested parties, including the trade press, congressional interests, stakeholders, NTIA staff, where your proposal affects federal government users, before launching your proposal at the FCC. Try to build as many coalitions among private sector interests and public interest groups as possible in support of your proposal. Try to submit a comprehensive solution to the FCC. Don't be afraid to kind of identify to the FCC staff all of the problems or hurdles involved in implementing your proposal. Let them know what they are. They will appreciate that, but try to help them figure out their way around those issues if possible. And always strive to show how your proposal is consistent with the FCC's major policy objectives. Very important. And each FCC chairman is going to have a different set of policy goals and objectives. And finally, the don'ts. Try not to be overly critical of existing FCC policy directions that make achievement of your goals more difficult. Try not to maneuver around FCC staff with day-to-day responsibility for your issue. They will not appreciate it. Please don't settle for sloppy engineering, legal, and policy analysis. It will hurt you and will make it more difficult for you to achieve your goals in the long run. And try to avoid pitting certain FCC bureaus and offices against each other. Peter and I were at the FCC during many battles between satellite interests and terrestrial wireless interests over spectrum. And I can tell you there is a little bit of industry capture at the FCC. We regret it, but I think it has to do with the fact that we have these stovepipes with various bureaus regulating various segments of the industry. And as a result, sometimes the bureau that deals with the satellite industry, and in most cases that's the International Bureau, and the bureau dealing with the terrestrial wireless industry, and in most cases that is the Wireless Bureau, battled each other. And often we looked, actually, Peter and I and our colleagues looked to the Office of Engineering and Technology to actually resolve those disputes. But if you can, it's important to sort of keep in mind that the FCC, the goal of the staff at the FCC is really to promote the public interest, and you try to be consistent in your messaging regardless of who you talk to at the Commission. It will, in the long run, be quite helpful for you to do that. So I think that's the end of my presentation on process. I'm going to turn it back over to Peter to start the discussion regarding the wireless regulatory framework.
Great, thanks, Ari. That was incredibly valuable insights that most people don't get. And if your company or you are developing technology, you may have to get a regulatory change, and those are the core processes that you need to do to get that. On the other hand, hopefully the technology you're developing or the company is developing would fit within the existing regulatory framework, so you don't really need to get any changes. So this is, we'll dive in now and cover for about the next 10 minutes the substantive aspects in the regulatory framework and the concepts there, and suggest some trends there, some examples. If we have time, we can always go back in the Q&A time if there's questions about particular proceedings as well. And touch upon the current focus on the shortage of spectrum wireless for broadband services. So there are three main components that I kind of identify under this regulatory framework. But it applies in the U.S. You can translate it into international proceedings as well. As you've got different spectrum access methods. You've got the equipment or the system certification or coordination aspects of it, and you've got the operational limitations. So we're going to kind of flip-flop back, and I'm going to let Ari talk about the kind of the traditional spectrum access methods.
So with the basically the traditional spectrum access methods are exclusive licensing and shared use of frequencies. And here, this slide just provides some examples of the exclusive licensing regime. One I want to point out is the cellular architectures in particular, geographic area licenses with no restrictions on where you place your base stations. You secure a license, it's freely transferable, you can lease it, you can pretty much do with it what you want, very few use restrictions, some technical rules that apply to your operation, but no significant use restrictions. And then the other another sort of traditional way of licensing involves shared use. Frequency coordination, site-based, decentralized trunking are all examples.
The other example of kind of a more evolving spectrum access method are the unlicensed approaches, where you've got more open entry to many types of very low power RF devices, garage door openers, Wi-Fi, the big examples, cordless phones. Typically, these have been in the past junk bands like a 900, 2.4 gigahertz, 5 gigahertz, where you got to share it with microwave ovens or radars or other devices. Ultra-wideband is a kind of more relatively recent thing that Ari and I worked on at the FCC. Covers big wide swath of spectrum on very, very low power basis, on an unlicensed basis. Technical requirements may include like dynamic frequency selection, transmit power control, or geolocation database or sensing based sharing, like more recently in the TV white spaces.
And there are also hybrid approaches to licensing, and we've seen that one of the hybrid approaches is the license by rule regime. Some examples are listed here on the slide: CB radio, family radio service, medical telemetry. This is where certain eligible entities are granted the right to operate on the frequencies by rule. They don't have to apply directly to the FCC for a license. They're sort of granted that right by rule. Another hybrid approach would be a site registration and automated link coordination approach. We've seen that with respect to the 70 to 90 gigahertz band. And then another one that the FCC implemented more recently is the contention-based protocols with site-based registration. We've seen that in the 3650 to 3700 megahertz band, where the FCC is granting nationwide non-exclusive licenses, but is requiring base station registrations before operation. Interesting thing about 3650 to 3700 is that previously registered base stations do not enjoy greater rights to be free from interference than base stations registered after. There is a general, somewhat ambiguous sort of obligation for all of the base station operators the base stations to cooperate, or the licensees to cooperate with each other in order to avoid harmful interference. But this obligation actually applies to incumbents and non-incumbents alike in that band.
And the last area is the private commons, which comes out of the secondary markets proceeding, where you might have a licensed band and there's authority to basically authorize equipment in that band if you're the licensee on a commons kind of all-com basis, if the equipment meets your own criteria for sharing that band. So in the equipment and system certification area, this is just to mention this. I mean, at the FCC assures compliance with service rules and interference avoidance requirements. You have to get your equipment tested by an independent lab. Typically, sometimes you have to submit it to the FCC lab itself, especially, for example, if it's deemed a software-defined radio, because you have to show that there's assurances for security if it meets that definition of software-defined radio. There's also a big focus on electromagnetic field health effects, radiation coming from transmitters, and the impact that has on humans. So that is a big focus when they evaluate this equipment. At NTIA, there's a similar or another kind of process you go through to assure that there's spectrum supportability and otherwise approval for government systems, and including electromagnetic compatibility issues. Just to mention we're not experts on this, but Europe, I believe, is kind of more of a self-certification approach, but I think there's some examining that as well.
A bit on spectrum allocations. The global spectrum allocations are made at the World Radio Conference. The next one is going to be coming up in January of 2012. These global allocations tend to be quite broad categories such as fixed, mobile, fixed satellite, mobile satellite broadcasting. And then once the global allocations are made, the domestic allocations are affected, and they tend to be a bit more narrow. For example, under the global allocation mobile, the PCS in the U.S. falls under that category. You'll see in the and the various services like PCS and others sort of fall under, you know, the more the FCC comes up with these categories like PCS and AWS, and they fall under the more the broader allocations that are affected globally. Priority access mechanisms. We could spend a lot of time talking about the difference between primary, co-primary, secondary. When you can operate on when you should be operating on a non-interference basis. The good rule of thumb is for licensed services, if you're primary, that means that you are protected from interference from everyone who has a lower status than you have. If you're secondary, you have to protect the primary licensee, and if you're operating unlicensed, pursuant to Part 15, you must operate on a non-interference basis, and you must also have the ability to you have no rights to be free from interference. You don't have the same rights that a licensee would have to be free from harmful interference. You must be capable of protecting yourself from interference from other services.
I just also want to mention, to remind folks to put their questions in. So far we've only got one question, but we'll open it up for audio questions as well. But we're going to delve in, we might dip into the question period a little bit since we only have one question, and it's about getting the slides, and of course you're going to be able to get the slides. We'll make those available afterwards. With regard to allocations, just want to mention that, you know, there's mobile fixed broadcasting services. There's 29 different allocated services for non-federal applications and 26 different ones for federal uses in the U.S. So more like there's amateur services, broadcasting, land mobile, you know, maritime mobile, satellite, all kinds of satellite services, radio location, radio navigation services, and they go back quite a ways. So the allocation table is quite a daunting thing to take a look at, but it's, you know, I think your first level of, you know, am I allowed to do this, you know, within a country or a region of the international, or do I have to go get the table changed either at the ITU or at the FCC to allow, for example, a fixed or mobile service?
Peter makes a really good point. Your first step, if you're trying to introduce a new service or new technology, is to first look to see whether you can do what you want to do under the existing rules. And as he indicated, your first step is to take a look at the table of allocations to find out if your application falls generally under that table, then to look at the rules that apply to the particular spectrum band that you're focusing on. And hopefully you are able to do what you want to do under the existing rules. If you can, then that obviously cuts down significantly on the amount of time that it's going to take to implement your service or application.
And so here are some of the operational limitations that are contained in the wireless service rules. You know, you have narrower service categories that are established by the FCC or the regulator, like paging, cellular, PCS, which stands for Personal Communication Services, SMR. There's a more broader categories of services like the Wireless Communication Service, WCS, and covers all kinds of different bands and services. It has each service rule. Sometimes they have classifications of the stations. the type of stations that can use the bands. There's channelization plans, allotments, band plans that are adopted. Sometimes there's eligibility limits. For example, with public safety, or generally in the commercial bands, there's no eligibility limits. Technical rules take up a lot of the ink in the rules about power, height, out-of-band limit restrictions. There's also performance and build-out restrictions so that the spectrum doesn't get warehoused. Sometimes, and they vary, sometimes it's a broad substantial service requirement. Sometimes you've got to build out 50% of the or a certain percentage of the population within a service area by a certain time. If you're building a network-based commercial type system, then you got other regulatory requirements on top of those, such as interconnection issues. Roaming is a hot topic right now. E911 requirements, disability access. So if you fit within a service category, from a network perspective, other requirements may kick in. And then there's a variety of social competition and industrial policies that sometimes attach to a radio service, to prevent somebody from having too much spectrum and not having a competitive marketplace, or making sure that broadcasters, for example, serve the public interest.
Those tend to be the ones that the disputes regarding what Peter referred to as industrial policy tend to be the most politicized disputes at the Commission, politicized spectrum policy disputes at the Commission, because obviously there are those social policy issues they often highlight the differences in philosophy between Democrats and Republicans.
Okay. So we're really running short on time, so I'd like to just really touch upon some regulatory trends, which I think are positive for folks that are developing technology. And mainly, it's a emergence of market-oriented regulation that is flexible service rules. And the example, basically started back in the 90s with PCS. And then it's kind of continued on with the new mobile wireless services, 3G, 4G. These flexible service rules allow you, instead of having to go back to the FCC every time you want to add, a technological innovation, basically just do it on your own. You have the flexible, usually the owner of the license has the flexibility to upgrade from 2G to 3G to 4G. Sometimes if it doesn't have the spectrum, it has to go to the FCC to get the spectrum. But if it has the spectrum, it can just make these changes on its own. And that's why the Commission has auctioned it off with flexible use, large spectrum blocks. It allows for disaggregation and partitioning of licenses on a geographic or spectral basis. So secondary market leasing, you don't have to go get a license. You can go directly to the licensee and say, I'd like to lease the spectrum from you that you're not using at this particular place or area, and other kinds of sharing, and transition schemes for freeing up the new spectrum. And I'm not going to mention this, but you can refer to this. But it's just one of those issues that comes up is, how do the access to spectrum has a cost. What is that cost, and what are the values there? And it's very uncertain. Hot debate, and so now the focus is on the broadband spectrum shortage, and lots going on here. And with that, I think we're going to open up for Q&A for about 10 minutes, or how much every time we can do it. Lee, you want to any questions?
Sure, thanks, Peter.
Open it up?
I have two questions in the queue, and then if people have additional questions, they can either type them in or else they can raise their hand, and we can, and I'll unmute your microphone so that you can present them. So the first question I have, Peter and Ari, is TV stations' effective radiated power is obviously determined by antenna height and configuration. Does the FCC regulate changes in antenna configuration?
For broadcasting, I believe they do. I think any change involving a broadcast station does require you to seek a modification of the license from the Video Services Division within the Media Bureau. Sometimes it's a minor modification, which is a RE just very scratch the surface on the processes. There's lots of other processes that go on at the FCC to get changes, like the licensing processes. So to the extent that your antenna configuration, your height, stuff like that, it affects your interference contour, for example, you're going to have to change to that. You're going to have to you're going to have to seek that permission in broadcast services. Broadcast services are what we continue to be under a command and control regime. That is pretty much any change you make, you have to seek permission. The question is it a major change or a minor change? And that will determine the process that you have to go under. A major change is like if you're going to change like the licensed city, and if you're going to change the height and configuration of your antenna, for example, and it's going to cover a much broader area, you're likely going to impact other broadcast stations, so you're going to have to get a permission. It might that modification may go up for public notice. There might be other procedures involved there.
Peter just made the point that I was also going to make about the contrasting the regulatory regime that applies to broadcasting, sort of an old command and control type service, to the process that applies to the wide area commercial wireless services, which provide a lot more flexibility. And again, the contrast is very stark. When the Commission started auctioning wireless spectrum, it decided to really give the licensees a lot more quasi-property rights in the spectrum themselves, allowing them to do all the things that Peter mentioned. With TV broadcasting, a licensing regime that was developed much earlier, before the market-oriented sort of approaches that we have today were developed. There are a lot of vestiges of that old regime that make it very regulatory, I guess I'd say regulation heavy and regulation intensive to operate a TV, to do anything in the TV broadcasting area. The Commission's trying to has from time to time taken a look at reforming that process, but it's a very slow process. And so as a result, there's a lot more regulatory baggage that comes with operating a TV station than would be the case if you were building out a wireless network today.
Next question.
So the next question is, if a change occurs during the World Radio Conference, who's in charge of reflecting that change domestically, NTIA or FCC, and how long does it usually take for the spectrum allocation to change?
Well, it really depends on whether the change affects government spectrum or private spectrum, commercial spectrum. If the change requires, if the ITU change, the World Radio Conference, affects the new global allocation or makes a change in a global allocation that affects services that are provided by government entities, then NTIA will start the process of changing the domestic allocation. If the change relates more to spectrum that's used for commercial services, or spectrum that is exclusively for commercial services, then the FCC will start the process of affecting the change. In a lot of cases, the changes affect both government and commercial operations, and in that case, the FCC and NTIA cooperate in implementing domestically the change that's made at the global level.
And these processes can happen in parallel, the domestic process and the international process. Many times, especially like involving satellite services, we've seen the domestic proposal be maybe conditioned on an international allocation being made or something like that. But typically that would help compress the time frame. If you had to do them in series, like okay, go to the ITU, get the because those WRCs. They only happen with every 3-4 years. Right. So you're going to typically, at least in the U.S., there are some countries though that rely on, because they don't have a robust regulatory establishment like in the U.S. They have to rely on everything that comes out of the ITU as their regulations. But in the U.S., we typically start those processes even before the international process gets going. So that's the way it varies. The time frame varies of when you're going to get a new allocation.
So we're running a bit late, so we'll do one last question, and then we'll close the webinar. Others who have submitted questions, what we'll do is we'll actually type up responses and send them to you privately.
And also want to point out, Lee, before you get to that last question, the last slide, I did have a couple references here with links. So when we put the slides up on the link, they'll have this. Go to this last slide, and you can really get some good basic information about the spectrum regulation from these sources. So many of your questions might be in those, or you can feel free to contact us.
Thank you, Peter. So the last question is, what's the latest on the auction of the D block broadband spectrum? Does the FCC still support the auction? Does Congress?
Well, I'll start with that, Peter, and be interested in your thoughts about it. Well, the auctioning of the D block spectrum has been held up primarily because the chairman of the Senate Commerce Committee, Senator Rockefeller, has submitted a bill, has introduced a bill that would reallocate the D block, which is currently allocated for commercial mobile use, to reallocate that for public safety.
That's part of the 700 megahertz band in the U.S.
Yeah, and the public safety community is very much behind that. President Obama signaled his support for it earlier this year, notwithstanding the fact that prior to that, the FCC chairman and most of the other commissioners at the FCC had signaled their interest in re-auctioning the D block for commercial use. So, and the law currently requires that the spectrum be auctioned for commercial use and not allocated to public safety. So the D block's being held up right now, and realistically, I don't expect anything to happen with the D block, any movement toward an auction or re-auction of the D block until the legislative issue gets resolved, whether the Congress is going to actually reallocate it or not. One more note on that. Although there is a lot of support in the Senate for reallocating the D block for public safety use, there's less support in the House. So right now there seems to be a little bit of a disagreement between the House and the Senate as to what should happen with that spectrum.
I have nothing to add.
Okay, well, with that answer then, we'll conclude this inaugural webinar of the Forum's webinar series. I want to thank the presenters for putting together these materials and making them available to the community. I know that's a lot of work involved in pulling together a presentation here, so thank you very much. Thank you also to everyone who attended. I hope you got value out of the webinar, and it provided you with what you were looking for. Just a quick announcement, our next webinar is going to be focused on SCA technology, and that'll be at the end of May, and I hope to see some of you online again there. We'll be sending out a satisfaction survey to get your feedback on how this worked, the format that we used, and to see if there's any things that we can do to improve these in the future. So I hope that once you get those, you'll take the time to fill them out. Thank you again, everybody, and we'll see you online later.
Thank you.
Thank you.